So good afternoon, everyone. Please welcome to the Walters Kluwer Law Arbitration webinar. The topic for our webinar today is Reimagining the Future of Arbitration, especially given the COVID-19 situation and how we are adapting. We have some really eminent speakers with us today as part of our dialogue. We have Mr. Shreyas Jarasimha from ANA Law, Mr. Chirag Balian from the MNLU Mumbai, Mr. Reena Petit from Norton Rose Fulbright, Mr. Tejas Karia from Amarchand Mangaldas Co. Shadul, and also Mr. Gautam Bhattacharya from Reed Smith. So without much ado, I will launch into the topic for this webinar and maybe talk a little bit about Walters Kluwer. As you know, Walters Kluwer is nearly a 200-year-old firm. We started with legal solutions back in the day in the Netherlands. And we, of course, are widespread out across the world with nearly 180 countries and more than 40,000 employees. We are about a $5 billion company. And, particularly for legal, we are very proud to say that, law arbitration is the gold standard, the world's most unrivaled and indispensable resource. We also have a very, very popular and well-regarded mediation blog, KMB, which provides a lot of fresh and high-quality examination of, international mediation, which is linked to our topic today. In addition to arbitration and mediation, we also have some solutions for you around competition law, as well as IP and tax solutions. So I will not take too much time, but I will hand over to Shreyas, who's, of course, an expert in the field, to take over. And thank you again, everyone, for joining in, and to the panelists for making this panel a wonderful collection of intelligence.
Thank you very much for that pithy introduction, Chris. It is an honor to participate as moderator amongst friends who are eminent speakers that you will hear from today. And the topic that is given to us is a fairly wide canvas. And so the challenge we have is to cover it all adequately. I would request those listeners to please use the Q&A box to please post in their questions even while we are proceeding with the webinar. I see that we are also a full panel now. So without further ado, we will begin with in the first segment, looking at the extent of disruption that COVID and the economic aftermath has caused to international dispute resolution processes, and in particular, the impact on arbitral tribunals, counsel, and their both barrister sets as well as firms, also arbitral institutions. And with that, I will pass on to Sharina, who's best placed to address this at a broad brush. Sharina.
Sorry, I had myself on mute. Thanks, Shreyas. Arbitration boasts an inherent flexibility, and that is what makes it attractive as a dispute resolution tool. But obviously, it hasn't been unsusceptible to the disruption of COVID-19. So looking at the disruption with arbitral institutions, many arbitration centers took precautionary steps shortly after COVID-19 received its pandemic status to safeguard the health and the well-being of their employees and users. They instructed staff to work remotely. They assisted staff to overcome technology issues, to set up working from home seamlessly. And I personally, whilst dealing with institutions on my cases, have not felt any disruption from the institutions. However, I do know from being on the board of the LCIA that a lot of work went on behind the scenes so that we could see the seamless transition. Some arbitration centers like the LCIA have developed online portals where parties can file requests for arbitrations, responses, applications for expedited formation of the tribunals, and more. Further, in an unprecedented move, aiming to ensure the smooth running of international arbitration throughout the pandemic, a number of institutions like the LCIA, the ICC, SIAC, for the first time came together and made a joint statement on arbitration and COVID. The statement committed to support international arbitration, to ensure that pending cases could continue and that parties may have their cases heard without undue delay. In particular, the statement emphasized the importance of collaboration as institutions look to make use of digital technology for remote working. Following this, many arbitration centers have encouraged and supported parties using virtual hearings, e-hearing services, and assisting parties in a pre-hearing preparation. So in fact, one of my partners has recently been involved in a hearing organized through Ihds, where Ihds actually assisted throughout the process, including doing a dry run, agreeing all the logistical points ahead of time. And according to my partner, he said it was absolutely invaluable. Moving on to the disruption of tribunals. It's interesting because I was looking at statistics of 2018, where Queen Mary University did a study, and they found, this is pre-COVID obviously, that 78% of tribunal members had never or only rarely taken part in hearings where all participants were in different locations. Seeing these statistics, I would therefore say that the biggest disruption for tribunals has been the move away from in-person hearings to virtual hearings, which is the new normal. In fact, pre-COVID, I was involved in an arbitration where parties were extensively liaising for weeks pre-COVID, reiterating the need for an in-person hearing and how important it was, etc. COVID-19 hit, the parties, counsel and tribunal were left with no option but to have a virtual hearing. Was it a success? Yes. And it saved the clients significant travel and accommodation costs as well, as counsel, clients and tribunals were going to be flying into London from all over the world. However, I know that a significant issue with virtual hearings that tribunals are facing is the loss of the in-person observation of witness testimony across cross-examination. And I know some tribunals find it interesting to look into the eyes of a witness clearer on camera, but others feel that it is quite difficult to capture the look and the feel of a witness online and their body language, their facial expressions. There's also concern that the witness could be coached off camera or reading from a script. Moving on to disruption for counsel. The majority of law firms and barristers found themselves working remotely, and for the most part, it hasn't been disruptive. Correspondence, pleadings, statements, submissions, applications, all being drafted remotely. However, I have found that disclosure and hearing bundles, it is becoming increasingly easy to manage it remotely, but some clients have found it difficult to deal with disclosure, particularly where it's been impossible to access hard copy documents or clients have not had suitable technology for storing data. The pandemic has also caused disruption in taking witness or expert evidence remotely as well. It's far more difficult to obtain that level of detail required from experts and witnesses over a telephone or via video conference compared to the face-to-face. And on the last point of the disruption of awards, there really hasn't been, I think, a material impact on the provision of awards electronically. However, I know there are some concerns about enforcement of awards due to the lack of due process. Due process concerns are often raised as an obstacle to virtual hearings. So for example, how can opposing counsel and the tribunal be confident that a witness is not being coached by someone off screen through instant messaging or by annotations of materials that are not visible on screen? Another common concern is to prevent ex parte communication with the tribunal. So for example, if one party joins a virtual hearing early or a party is disconnected partway through the hearing. I know that materials are published by some institutions and there are some protocols offering practical solutions for how to mitigate these concerns, which I will touch upon later. But I think, Shreyas, I can see that I'm running out of time, so I'll hand over back to you. Thank you.
Thank you for that excellent overview from London. Tejas, if we can hear from you, we've heard what it looks like internationally. Of course, you have a vast international practice as well. But could you also speak to the level of disruption you've seen domestically, in addition to your comments internationally? Tejas?
Sure. Thanks, Shreyas, and good afternoon, everyone. So talking about some kind of disruption which we all are facing in our daily life due to COVID, because of maybe we all are working from home or restricted kind of movement and meeting people, has also transgressed into the arbitration world. And to begin with, the few weeks, everything came to standstill, including all the court proceedings and all arbitration hearings, where we were to fly to different jurisdictions and do a lot of domestic arbitration, but everybody was quite cautious and disrupted the whole process. But now we have realized that it's a new normal, as Sharina rightly put it, and we have to move on. And what we have now done is, and we will talk later part of this webinar about the technology, and have started using the technology to the maximum advantage. And in India, we have a lot of ad hoc arbitrations. And now I have realized that even in ad hoc arbitrations, we have started using video conferencing to continue the hearing. The good part is that the Supreme Court has realized the difficulty and passed an order on 6th May, extending all the limitation which is there in the arbitration proceedings. So we have the limitation for maybe filing of the pleadings or completion of the proceedings and passing of the award, or limitation for challenging an award which was made during this period. So that has come as a big relief as far as the limitation period is concerned. But apart from that, we have seen that the Indian institutions have also kind of kept up to the speed with the other institutions outside India, and encouraging video conference facilities. And we are now moving towards an era where we may be continuing with it post-COVID also. So the kind of comfort which we are having, although there are challenges with using the technology, but with the kind of benefits we may have with this new normal, it's rather than disruption, it has given like a new reset to our whole arbitration process. And we all should consider and see that whether we should take this disruption in a more positive way. But as far as India is concerned, we are doing full day arbitrations now, back to normal, and we are continuing to do the arbitrations even outside India. Only difficulty which I see is a lot of foreign awards are not getting enforced in time, because of the courts are only taking the urgent matters as of now, and it is getting extended every 2 weeks as we're not coming out of this situation very soon. So the concern is that we have a lot of clients outside who want to enforce their award, which are foreign awards, and in India, which is not happening. The final hearing of those cases are not taking place. As far as urgent interim relief of Section 9s for interim measures, we are filing it and getting the hearing done, and courts are very receptive through grant of interim relief by video conferencing. Even challenge of the awards, we are able to file it, and if we need some urgent relief in terms of getting a post-award interim measures also, we are able to get it fairly quickly. So things have changed and for good, and we hope that we continue with this progress.
Great, that's a fantastic segue to the over to you, Gautam. Could to elaborate a little more on what Tejas said just now. One factor that we see in the webinar scale is you don't hear about pandemic as force majeure anymore. We heard only that in the first week. Now, as I think there is really an acceptance to looking beyond the fact that this is one-off. And as Tejas alluded, Gautam, can you tell us what are the courts and let's say even the international commercial courts, not just the seat courts, how are they reacting to this level of disruption, Gautam?
Sure. Thank you, Shreyas. And hello, everybody. Thank you for being on this webinar. It's great to be on it. You know, I think we all accept we're in a new different now, and remote hearings are here to stay, and there's no doubt about that. And that
Gautam, you'll have to unmute, please.
I knew I would do something wrong. I knew my technology was going to be hopeless. I'm sorry. I will start again. Hello, everybody. Great to be on. And thank you all for participating on this webinar. You know, we all accept that we're in a new different now, and remote hearings are here to stay, which is a very good thing because frankly, it'll drive efficiency. It'll drive less delay in my view. And a lot of these things that we're going to talk about today, given that the topic of this webinar is reimagining international arbitration. We do need to reimagine. We need to innovate, be different, think differently. And the courts have reacted. And I'm going to give some perspectives from the English courts and from the Singapore courts in terms of how things have happened and to try to draw some points together from this. The English courts have actually responded very well. Remote hearings began almost immediately after the lockdown happened here in March. And there's a real sort of business as usual, as far as possible mentality. I mean, clearly some things, you know, like full trials are not always possible, but we were involved in in fact, the first trial, 5-day trial in the commercial court during lockdown before Mr. Justice Tier, a High Court judge in the commercial court, which was about the enforcement of an award here. And that involved the examination of factual witnesses and also expert witnesses. And that all happened remotely. So that was a 5-day hearing in front of a commercial court judge. And you know, these things are, and that set a great benchmark for what we can achieve here. And frankly, that's a really good thing. Things haven't come to a pause. And you know, in terms of how we do all these things, remote hearings are going to be inevitably hugely dependent upon technology and the availability of technology, and that it works. Now, I know we take that for granted here in the UK. We take it for granted in other countries, but that is something that if it works really well. And I think the experience in Singapore is very similar. The Singapore courts also have got on with things. Some things have had to be postponed, of course, but as far as possible, the Singapore courts have got on with things. The judges have got on with things, and they've ensured that judgments have been delivered. Now, for the purposes of enforcement of awards, for example, it would be, in my view, extremely counterintuitive if things just came to a halt, especially in pro-arbitration jurisdictions like the UK and Singapore. And so it's only right that these sorts of matters have also received urgency and attention. And there's a very good example, actually, it's very topical, actually, Shreyas. Yesterday, the English High Court gave judgment in a matter where they set aside an objection to service in respect of the enforcement of a $2 billion award against the Republic of Egypt. Now, that's a very good example of the fact that the English courts just get on with things and there's no delay. And that's very important because we all know that people are watching very carefully as to what's happening, how are courts reacting, how are lawyers reacting. And the fact that these things are going on is very good because it shows that as a jurisdiction, we are getting on with things well and our reputation is being maintained. So I would say that's a very, very good thing. And, you know, my last point I'll make, because I'm mindful of time, is that there are lots of other positives about how technology has been very good to ensure that arbitration and litigation working in harmony work well, because I hope we'll come to these themes, and indeed I'm sure we will under your expert chairmanship, Shreyas. We'll get to these things, but things like giving opportunities to more people, ensuring that counsel are more savvy, get with it, you know, don't just abide by the old, you know, the good old-fashioned days where they could get away with so many things and everyone is at their beck and call. things have to move forward. In fact, I think it'll enhance efficiency. I hope give more counsel opportunity to show their skills, and also to lower some of the astronomical fees which some counsel charge very often for not a very good job. So on that rather controversial note, I'll hand over back to you, Shreyas.
Thank you for promising milk and honey and perfection in the current world. One of the themes, in addition to you responding to what Gautam said, given that you're an academic and already questions have started coming in to say, what do students do? So one part of it, of course, please do speak to the way you have observed Indian courts work and the issues with platforms, but also give a minute to reflect on students, since I see a lot of questions coming up on that score. You're on mute.
So, yeah, thank you, Shreyas. And thank you, Gautam, for reflecting wonderfully on the London courts and the Singapore courts. See, looking statistically, as far as Delhi courts are concerned, we know that since lockdown, 20,000 matters have been heard virtually by the Delhi courts. And same is the trend across all the states as well. To my mind, I think there are three important judgments in the lockdown, at least on the question of interim relief, which we must note. First, the judgment which is already pointed out by Tejas, a judgment by the Supreme Court, wherein the limitation period is extended. A second judgment comes from the Bombay High Court, wherein the issue was whether steel, working on steel is an essential service or not, or whether that will fall under force majeure contract, force majeure clause or not. Bombay High Court said no, steel was still an essential service during the lockdown, and that's why it does not, failure to work on that does not fall under force majeure exception. And the third important judgment comes from Delhi High Court, wherein the question was regarding whether, about the interim relief, whether bank guarantees can be acted upon during the lockdown period. And therein, the court came up with a novel approach. They said definitely fraud is one of the ground and irretrievable harm is another ground to order injunction in such cases. The court said special equities can again be one such circumstance where interim relief injunction can be granted so that the bank guarantees cannot be impounded. So qualitatively in terms of number as well as qualitatively in terms of the nature of judgments which has come in the lockdown, as well as quantitatively the number of cases which has been heard. Though they said they are hearing urgent matters, I think the Indian courts have done a great job in coping up and adjusting to the virtual reality.
Excellent. Thank you for that comment. Moving slightly onwards to the economic impacts of the levels of disruption. There are obviously some winners and losers with every unforeseen event. It has unintended consequences, unimaginable consequences. But now with the benefit of a few months of hindsight, can I direct this question to Tejas to tell us where are, Tejas, the domains and industries where you are seeing COVID and market disruption generating more significant disputes than other sectors?
Sure. So in terms of disputes, what we apprehend and that has started flowing in is all the construction contracts, which are time-bound contracts where they have to finish the infrastructure projects within the stipulated time. And we see that is not happening because of various reasons. Is that raw materials are not available, or the labor force who have a lot of part of that is migrant laborers who have gone back to their places, and we have seen that particular aspect due to this specific event which has taken place. Lot depends on the force majeure clause under the contract, because there could be a situation where in one of our contracts, fortunately, it mentions epidemic. And we were quite surprised to see that we put it there without even imagining that it would be there. And it kind of saved us a lot of money. So drafting of the contract in any sector would make a lot of difference when it comes to force majeure. And also, we have to see that what are the financial requirements, because most of these projects are funded. And even if there is a force majeure, the funding may not, the repayment or anything may not stop. So we have to see what is the effect of the suspension of the work or the extension of time, because extension of time may also have an implication on increase in the cost. So the governing law of the contract would also play a major role, because it lot depends on how the contract has to be interpreted by the arbitral tribunal. And we see that procedural requirement under the contract, for example, a notice has to be given under the force majeure clause and not given, or what are the mitigation aspects which are taken into consideration, the tribunal will see a major part of argument would depend on that. Other sectors, if we talk about, is all the logistics and travel and tourism kind of industry, where we have seen a major disruption. That could also lead to major disputes. Apart from that, the export and import businesses, where we have cross-border contracts for supply of goods and services, that could also see a major rise in the dispute. What we feel is that in addition to arbitration, mediation can also play a major role in coming days. Because if you talk of arbitration, yes, there is very limited to argue, because it's a known fact, and as Shreyas rightly put it, is that now parties have started accepting both sides, because both may need to take benefit of this COVID-19 situation. And they have to continue with the commercial relationship. What we have started seeing is also that the parties who could have performed are also trying to take the advantage of this situation just to delay the performance. And that is also not good, because ultimately we have to all come out of this situation together, and mediation can play a major role if you have an institutionalized mediation, which we expedited the technological advancement. We should also bring in the mediation, which is in a structured format, to resolve this dispute, because there is nothing much to prove in arbitration, and it cannot be adversarial, where the fact of COVID-19 is an admitted position. The only thing we need to do is interpret the contract and see where the performance could have been done despite COVID-19, and where the performance was barred because of COVID-19. So that those kind of situation can be resolved in a much faster and easier way if we try to combine med-arb or arb-med-arb, which could be a best model to resolve the dispute arising out of the COVID-19 situation.
Thank you for drawing attention to mediation in addition to few sectors. Sharina, do you have a different view of the types of industries or sectors that are particularly impacted, and which of them might see a more long-term change in the way things happen? Unmute, please.
Unmute. I agree with Tejas. I think one area in particular, which may be particularly ripe for disputes in the wake of COVID-19, is the construction sector. As governments across Europe begin to ease the lockdown restrictions, the impact of COVID on the construction industry is starting to reveal itself. Commercial construction plummeted overnight with social distancing and self-isolation measures. When these came into force, delivery times lengthened due to transport issues and supply storages. Other factors included sicknesses, repatriation of migrant workers, all of which obviously had a major effect on productivity. Construction was also one of the only handful of sectors not subject to blanket shutdowns by governments, which created problems for site operators and contractors. who were expecting to continue working despite lacking labor and materials. And this is what our clients were telling us. Generally, issuing claims for contractual breaches has so far not been the priority for parties involved in the construction projects, who've been mainly dealing with immediate issues, but it is anticipated that disputes will start to emerge as the dust settles. Businesses have also encouraged parties to avoid COVID-related disputes. I was reading a comment by Steve Bratt, who's a member of CLC Coronavirus Task Force, and he pointed out that the construction, infrastructure, and facilities management sector has hundreds and hundreds of small businesses linked by complex supply chains. And therefore, companies should look at the bigger picture and encourage fair contractual behavior. The view was reflected in new guidance from the Cabinet Office as well, which is the UK Cabinet Office, which has urged groups to act reasonably in enforcing contracts in light of the growing concerns that COVID-19 crisis will cause a spike in lawsuits and create a backlog in the civil courts and in arbitration. Similarly, the British Institute of International and Comparative Law has recognized that the international dispute resolution system, whether it's via court or whether it's via arbitration, is likely to come under considerable strain in the coming months and years. The other sectors, and I was reading a study, the other sectors that we've seen, that I was reading about, and also where I've seen my clients suffering, are hospitality, accommodation, food, mining, oil and gas, transportation, warehousing, and of course, aviation. Over back to you, Shreyas.
Thank you for that whirlwind industry tour and landing safely to the next topic, which is, we've spoken so far on commercial areas, but there is also the world of investment treaty disputes. And those of us who are active in this field are seeing the way in which it has its impact. There is a move in any event by UNCITRAL to try to overhaul the ISDS system. Meanwhile, there have been calls to seek to suspend the working of a few of these obligations. Can I request at this stage Chirag to walk us through what are the initial impacts on the ISDS system due to COVID, and how much of that is a long-term impact?
Thank you, Shreyas. Definitely, the extreme measures taken by the governments during COVID-19 pandemic could lead investors to file claims against the government under relevant VITs on ground of unfair treatment, direct or regulatory expropriation, etc. And this has been the trend in the past as well. Whenever there have been crises in the countries like Argentina, Belgium, Cyprus, we have seen that the number of ISDS claims have risen in response to the government claim. We can also take an example of Arab Spring after 2011-12. The government responses attracted number of ISDS claims. And therefore, in this pandemic also, there are apprehensions that there may be many investor claims against the government. Now, what are the options with the governments in such situation? Generally, under customary international law, there is an exception of necessity, which can be taken by the government. Under relevant VITs, there are certain exceptions. It depends now whether that exception is there in that VIT or not. Public health, public order, extreme emergency. At least in Indian context, there are many VITs which have this exception of extreme emergency. And over and above, there is always an exception of exercise of police power. We know that in the lockdown scenario, the state can always argue that what they did was the exercise of the police power by the state, and that is why the claim should not be sustainable. But an important point which one must remember in the context of ISDS claim is that the interpretation under various treaties is disparate. So whether the claim will stand or not is very tricky. It depends upon tribunal to tribunal. So while we have seen earlier take an example of necessity as a defense. While some tribunals have upheld it, some have refused to upheld the necessity as a defense. And the claims runs in billions of dollars. So for developing economies, it has a significant economic impact also. So what has happened in this context, many committees, many people are coming forward, academia is coming forward and saying that the government should come together and issue a moratorium against the ISDS claim. They should suspend the claim. So that's one option which has been suggested even by ISDS as well. The other option is they have said the government should again come in a concerted effort and give a uniform interpretation of various treaty clauses, so that again there's a concerted effort, there's an effort by the governments at large so that investor claims can be reduced, and it helps in a uniform treaty interpretation. But what we can importantly underline here is a novel approach used in India-Brazil BIT, where there's a move from investment protection to the diplomatic protection. Now, what has happened, they have said, we won't go for the investor-state dispute settlement under the treaty, but there'll be a joint committee to decide the dispute. And the scope of investor-state dispute is very limited under India-Brazil BIT. Therefore, to handle such kind of situation, pandemic kind of situation, these novel features can also be very important in avoiding big claim of damages or large amount of, because what happens, because see, again, there's so much money involved, there may be many companies who may be tempted by taking help of third-party funders to file the claims, unnecessary claims. And defending these claims, there is a study which say that take approximately 7 million rupees to the government. So I think it is in this broader context, this turbulence caused by pandemic in respect of ISDS need to be taken into consideration.
Thank you very much for that, Chirag. Gautam, could you also reflect in your response on this aspect that this pandemic isn't over, and it has also redefined what a developed country is, when you have seen deaths and destruction even with economically powerful nations. And so some arguments that you might have expected from some parts of the world might now be deployed from unusual parts of the world. So could you please take this into consideration when you respond, please?
Yes, of course. And, I unmuted because I fell into that trap before. I think, Chirag has raised a lot of really important points, because the whole area of investor-state arbitration, BITs, MITs, as we abbreviate them too, this is a rapidly evolving area. We all know the amounts involved are huge. These are public claims. It's the name and shame approach. Countries can't afford to be seen as bad bets for investment. These cases are very legal and very open, and public international law is a rapidly evolving area. But I think there will be some controversies in the sense of it's not always easy to lay down precise definitions. I mean, Chirag is right when he mentions there is a call for having more clearer definitions of what certain concepts mean. But I think, this pandemic may well bring claims, I agree, against some smaller states who haven't so far been subject to claims. But I think one of the key tensions here is, to what extent do we try to, in some ways, condone some of the executive sovereign behavior which some countries have had to take in response to such an unprecedented situation. It's one thing to terminate a mining concession in the good days for whatever reason. I'm not saying that's justified, but there are other reasons why self-help could be different in a pandemic time. So I think there is this natural tension there. I would raise that. I'm mindful of time, but I'd like to raise two other points, if I may, very briefly. One is in terms of reimagining what we're trying to do in arbitration. The Ihds cases I've been involved in before have always been quite tense affairs. You have people coming from the governments of the state. You have, people from the legal department, you have ministers, as well as, you know, us humble external lawyers. But these cases have a real tension, which is why remote hearings, in my experience, are not that well received in the investor state arbitration arena. There can be a perception that having an in-person hearing is more important because the stakes are higher, the reputational risk is higher, and the sort of the international name and shame could be higher as well. So I think that is one thing. We had an experience on this where some of my partners are involved in a matter at the moment where a hearing was postponed from earlier this year to take place in January next year, because it was felt that would be a safe, quote, time to have a in-person hearing again. Now we'll see whether that is indeed a safe time to have one. But the other thing I would also mention is, and we'll come to this, I'm sure, later on, in terms of new things, but to what extent this pandemic might encourage third-party funders to take a bigger interest in cases brought against states or maybe for the state, where we are dealing with these sorts of important concepts, which to so many of us, despite the gray hair which I have, none of us have seen a pandemic before.
No, thank you. And it is very unusual to suggest that third-party funds might be interested in state positions, but we never know how this space will evolve. Now, with that, we move to the second phase of this webinar, which is more focusing on the reimagination and the green shoots. What are those emerging trends that will likely outlast this conclusion of this phase, or in fact, new phases of a pandemic? We hear of a fresh one that might be in the works, God forbid. So, Sharina, can you walk us through some very practical best practices that you have seen being adopted and what could also be adopted going forward for conducting arbitral proceedings more efficiently in what is very clearly the new normal?
Thanks, Shreyas. I think the elephant in the room is obviously virtual hearings. As I mentioned previously in the study, the Queen Mary study of 2018, it was found that 78% of the arbitrators never or only rarely taken part in hearings where all participants were in different locations. Obviously, the statistics has changed. The coronavirus pandemic is requiring the arbitration community to adapt rapidly to a reality that will be from us for the medium or long term, with virtual hearings, as I already said, and as Tejas also said, as the new normal. I think it's worth noting and reiterating a point that Gautam made, that courts across the world have recognized the importance of virtual hearings for the proper administration of justice during the global lockdown. In fact, the English High Court and the Court of Appeal is continuing to hear all urgent matters. The London Commercial Court released a statement highlighting that the court's approach should be optimistic rather than hesitant, and that it is the duty of all parties to seek to cooperate to ensure that a remote hearing is possible. Parties should be encouraged to consider the ramifications of virtual hearings in advance. So in fact, in an arbitration where I'm counsel currently, we have been asked by the tribunal to consider the ramifications of the global pandemic on a week-long hearing, which is slated to take place mid next year. And they've asked us to make suggestions in respect of how this should be handled by the tribunal. The parties have all conferred, and some of the suggestions are that the service provider that's already been engaged to provide courtroom and document management services had developed a virtual hearing platform, which could be used for a partial or full virtual hearing. If there is to be a full or partial hearing, then reserving an additional breakout room and hearing rooms for the hearing dates to be able to comply with social distancing regulations. The other suggestion is reserving an additional week for the hearing and putting that week into the tribunal's diary now to take into account delays if some witnesses are required to give evidence by video link. The parties will of course assess whether a full virtual hearing will be required closer to the hearing dates. I think I was thinking about a few action points that parties can take to ensure they adapt best practices for a virtual arbitration hearing. And I would think some of them would be: one, considering obtaining agreement by all parties involved that the fact that the hearing is being conducted virtually will not be used as a ground to challenge the result of the hearing. Select an appropriate video conferencing platform in advance. Such a platform which provides robust protections for things like confidentiality, offers high resolution video imaging and quality audio, and enables participants to actually display documents across screens. Also, thirdly, I think it's important to consider that it might be useful to retain a third-party service provider to arrange, monitor, support, and troubleshoot the video conferencing system. The other point is to ensure that all parties, and in particular witnesses, are familiar with the platform chosen for the hearing and have suitable equipment to participate. So I think counsel for the party calling the witness should consider perhaps conducting a test session with the witness in advance of the proceeding on the chosen platform to go through any electronic exhibits. Another point is consider particularities of the procedural laws. So for example, consider whether applicable law authorizes the arbitrator to administer oaths to witnesses by video conferencing. And if not, determine a process to follow to ensure reliable testimony. And lastly, devise a process by which any participant who has temporarily lost an adequate connection to the chosen platform may promptly notify the arbitrator and other participants of that event. So for example, by text messaging that person, and identify a backup plan pursuant to which the parties will reconvene in the event that this occurs. I think in terms of the benefits of virtual hearing, and I know time is short, so I can't go into it, but if I was to pick one pro of virtual hearings, besides the obvious one of reducing time and cost, I think it would be to reduce the carbon footprint. And in fact, Lucy Greenwood, an independent arbitrator, started a campaign for greener arbitrations last summer, so pre-COVID, which is now called the Green Pledge, where she noted that the significant carbon footprint of the arbitral community. And she asked the arbitral community to pledge to try to reduce this, for example, by using video conferencing. Who knew that that was going to be the new normal of today? In terms of protocols, and I know there's been a question asked about this as well, I think if virtual hearings become the norm, a host of refinements and adjustments will be needed to tailor traditional procedural safeguards to the virtual hearing setting. And there are a number of soft law instruments that offer helpful guidance. By drawing from these existing resources, practitioners and arbitrators can make the task of organizing a case much easier without reinventing the wheel. And some of these include the ICC Commission Report on Information Technology in International Arbitration, the CIR Guidelines for Witness Conferencing in International Arbitration, and the Hague Conference, a draft guide to good practice on the use of video links under the Evidence Convention, and the Seoul Protocol on video conferencing. So these are all good soft law instruments, but they're helpful, and they're helpful to all parties. So to take an example, to address the concern as to the authenticity of witness evidence, Article 1 of the Seoul Protocol requires that a video conferencing system at the venue should allow a reasonable part of the interior of the room to be shown on the screen, while retaining sufficient proximity to clearly depict the witness. The witness shall give his or her testimony sitting at an empty desk or standing at a lectern, and his or face shall be clearly visible. With that, over to you, Shreyas, again.
It's amazing the minutiae of these recommendations, and I'm sure some of them will lead to a few cultural like moments. Gautam, what do you feel are some of the behavioral best practices that could be adopted? And is it really the answer to have more soft law since we have so much of softness of laws around us already?
Well, you know, Sharina has very nicely summarized the issues that we're all facing with remote hearings and what we're experiencing, technology, you know, getting things set up, testing, etc., and having the right platforms. So I'm not going to go into that. But what I would say is this, Shreyas, you know, I think, you know, again, going back to the concept, reimagining arbitration post-COVID or as a consequence of COVID, I would say these points in terms of how we make the process better. You know, let's just start from a basic, and I make this point with no apology. Arbitration is not a special black magic, some special world that we all live in, some intergalactic thing. It is a form of dispute resolution, pure and simple. And it's not for us to make it anything more fanciful than it needs to be. The clients are the people who we're trying to help here. We're not trying to become, you know, super people and everything else. The fact is we want to make an efficient process. It is ultimately just dispute resolution. Now, what I would say is this, and this is from my experiences, you know, from COVID and with my teams in terms of what we do. I think arbitrators, the biggest frustration I have that I had pre-COVID was very badly prepared arbitrators. And my experience has been in my 2 remote hearings that I've had since lockdown, the arbitrators have been incredibly well prepared. And I think that's one of the things that's happened. They've had to be better prepared because of the vagaries, which Shrina mentioned, of technology. And the fact that you're on screen. If you're in a room, sometimes you can be a bit of a non-listener. You can be fidgeting and that sort of thing. You can't do it so easily when you're on screen. And where there's 3 people and other people are on non-video when they're not actually on because you want to save bandwidth. That's the first thing. Second thing, I think there's in terms of efficiency, a much more importance now to written submissions. So in terms of written oral submission, written opening submissions, it's very important to really be mega clear in those, you know, because you know, people are going to be looking to prepare better. And part of that is better written submissions in advance of the hearing, which we've grown up in that tradition, but I think that's become more important. And in fact, you know, just using an experience I had from a remote hearing in a court matter, which happened in May, the judge in opening made the point that I've spent more time preparing for this hearing than I would ordinarily do, which was interesting because that sort of confirmed my sense of what was happening in arbitration. Now that was a 1-day court hearing, but where, you know, he said, I've spent time, and he was, you know, he clearly had. So I would say that. And my third point, and my last point is this, in terms of better practices, what do we want out of arbitration? We want better rewards. Now, I'm not sure to what extent soft law, your point about soft law is a very good point, but ultimately we want awards that are good, decent, and are not delayed. And one of the things that all of us have had as a big bugbear is how long it takes awards to actually be rendered. Sometimes it's criminal how long they take. And there's no excuse for that, quite frankly. So I'm hoping that one of the efficiencies we might get out of, you know, this COVID impact on arbitration, be it commercial arbitration or investor state arbitration, is that there will be less delay because the parties will say, you can't blame jet lag, you can't blame your carbon footprint, to utilize a point Sharina made, and all of these things. You've just got to get on with it. And if people aren't getting on with it and are just abiding by what they got away with in the pre-COVID days, I think that's a good thing because new arbitrators, better arbitrators, hungrier arbitrators will come to the fore.
Thank you. So in this brave new world, we've all agreed that tech plays a critical role. So in fact, we have two sub-segments right now, and we are running a little short on time, so I want to remind panelists on that. But I think we should spend some time on tech. First section is on the positive and lasting tech solutions, be it on ODR, case management, or others. And we'll come to the anxieties around tech in the next segment. So over to you, Tejas, please.
Yeah, thanks. So as we all agree that tech is the solution for the future, and we have very little option but to rely on tech. And it has proved to be a great tool to sustain ourselves, because otherwise we would be all out of a job if tech would not have been there with us. Having said that, it's not that we started using tech because of COVID. Like we always had tech as a support for arbitration processes. In fact, many rules, like for example, Rule 28.4 of Arbitral rules talks about witness examination through video conference. ICC rule talks, Rule 24.4 talks about video conferencing. LCIA Rule 19.2 again provides any hearing through video conference. So we have all the major institutions talking about video conferencing, and all of us who have been part of the arbitration process have experienced that at least some of the witnesses we have cross-examined through video conference or part of it. And now we are moving towards the entire platform, which is online. And there are two aspects to that. One is the hardware aspect, where you need the systems to provide the same bandwidth, connectivity, and a platform. Like there are many platforms which are there now. Zoom is there, Microsoft is providing platforms, BlueJeans. So all of these platforms are very good, but what it needs in practice is that you need to have multiple screens to manage the arbitrations, because most of the time, if you're using the online case management system, all documents are uploaded on the cloud, and you have to use those systems as well. Sometimes you need to also chat with your own colleagues who are not with you in the same room. We have found that the virtual breakout rooms have been very, very helpful for the parties to break out and talk to the witness, or arbitrators to confer among themselves. So the tech has proved to be a great tool. If you talk of soft law, again, there are a lot of etiquettes which are there. So ICC has come up with a guidance note for the possible measures for dealing with the COVID situation, and they have come up with a detailed guidelines where all the things which should be kept in mind. So before you go into the hearing, we should identify which platform is being used, what is the time zones, because time zone is the most critical thing when you talk about virtual hearing, because we have had situations where you have to start really early in India, or for Indian time to be managed, the arbitrator has to get up very early or start very late. So those things are to be kept in mind. How many people would log in? Because it's very difficult to keep a tab on the people who are joining due to confidentiality. And if somebody is joining, recording, it becomes an issue later on with regard to the confidentiality, which we will talk in slight detail. Now, if you talk about online case management, and this is something is very important for all of us to think about, is that although it's a bit expensive to go, but the kind of advantages it brings in for the case management, from starting from invoking the arbitration till the award, you have everything on a platform where you get the password and your own space, where there are many systems like Case Anywhere or Ihds Arbitration, which are the service providers. AAA has the service of WebFile. WIPO has ECAF. So all these platforms are already there, but the only difficulty is that in India, for ad hoc or institutions, we are not using these digital case management systems. The advantage of that is that instead of sending the heavy documentation, you can use the platform to file on a particular platform. You can access it very easily. you know exactly what is the status of the arbitration, you can track it, the timelines can be managed. Only downside of that is it's a bit expensive to begin with, but you can definitely cover up. AI again is a great tool to support the arbitration, maybe for the appointment of an arbitrator, selection of arbitrator, if you have enough data set for that, or discovery and production of documents. Because in a document heavy arbitration, what is a relevant document, we can definitely use AI to support us in terms of that. Also for the awards, maybe it could be good to at least, not for the reasoning part, but for the factual part, the technology can really help, and then the arbitrators could come in. So it's a separate discussion whether AI can replace arbitrator, but I think that's not the topic for today. But it's a very interesting thing, is that technology can be a great support for an arbitration, and it can be a great challenge as well. Over to you, Shreyas.
Thank you for that, Tejas. And quickly, Sharina, what is your view on the positive tech changes that you've seen? Any other tools?
Yes, I think, whilst contracts usually prescribe formal, lengthy, costly modes of dispute resolution, like formal arbitration, in the current crisis, the overriding desire for our clients is to resolve their disputes in a swift but fair manner. And this was actually recognized by senior members of the English judiciary as well. So for example, in the UK, Lords Neuberger and Phillips called for commercial disputes to be resolved by mediation and other ADR mechanisms to avoid a deluge of post-COVID litigation. I just had a client 2 days ago speak to me that they wanted to resolve all their disputes by mediation only. And so in light of the current climate, there are some new products that have been developed to assist companies in resolving COVID-19 related disputes. So for example, the London Chamber of Arbitration and Mediation has developed a new product which was launched in the market, offering expedited arbitration and mediation services through electronic means for a fixed fee, which are delivered by a diverse expert panel of arbitrators and mediators with years of experience in ADR. My firm, Norton Rose, has also developed a product called NRF Resolve. And this is an expedited legal framework for dispute resolution, and is developed by us, lawyers, administered through an online platform, supported by a Norton Rose Fulbright case manager, along with a Norton Rose Fulbright partner, or someone pre-approved third party. So for example, barristers, practitioners from other law firms, acting as a conciliator, mediator, or arbitrator to facilitate an expedited arbitration or mediation, and that's within 5 weeks, fixed fee. Back over to you, Shreyas.
That's fantastic. On the darker side of tech, we've already had a few questions on the digital divide and knowing that there's going to be tech disruption, but also there's one of access. And even beyond that, there are issues around security, which have come to pervade online dispute, any online process. Chirag, could you briefly comment on this? And I do want to say we need to reserve some time for questions. So could you please speak on this briefly, Chirag?
Yes, I'll try to be as brief as possible because a lot can be said about this issue. Cyber security and data privacy is a concern in arbitration, even in normal weather. In times of pandemic, when we are compulsorily saying that you have to rely upon the technology, you have to rely upon virtual hearing, the problem just gets amplified. Now, while it is true that the parties may choose to decide the reasonable security measures that shall govern their proceedings, the main difficulty in India, at least in India, is we don't have a data protection regime. And in this context, I would like to highlight two particular developments. First is Section 42A, introduced by 2019 Amendment Act, which provides for the confidentiality of proceedings. The point to be noted is that this section is only limited to arbitrator, arbitral institutions, and the parties to arbitration agreement. Now, what about service provider? What about technical assistance? how do you ensure confidentiality, especially in a virtual atmosphere? A second development which I would like to highlight, the point which Sharina also pointed out in the earlier part of the presentation, the number of measures which have been taken, proactive measures which have been taken by the institutions, and they came up also with the joint statement. In those measures, I'll take just two examples. One is the ICC guidance note, which Tejas referred to some time back, and how ICC guidance note provides that the parties and tribunal shall consult to implement measures that respect relevant data protection laws, privacy of hearing, and confidentiality of electronic communication. Second thing I want to point out is the protocol on cyber security in international arbitration, which lays down framework to determine reasonable information security measures for individual arbitration matters and mitigate the information security risk. Now, though there may be these institutional rules and protocol, be that as it may be, ultimately, I feel every user in arbitral process, and I'm consciously using the word user, I'm not saying parties, because the spectrum is very wide. So every user in arbitral process need to take individual steps to ensure privacy and confidentiality. Small steps like use of VPN secured internet connections, encrypted communications, pre-virtual arbitration agreement laying down digital hygiene measures can go a long way in respecting the integrity of arbitral process. I think much can be said about it, but due to paucity of time, I'll stop here. Thank you.
Thank you. And very nicely, the organizers have just told me that we have an extra 15 minutes. So that relieves some pressure. So Chirag, if you want to have a follow-up to what you hear from Tejas, after Tejas, you can take a minute. So Tejas, we've talked about the dark side of tech. Do you have more to say? And please do say something about replacement of all of us by AI. We'll all have a nice holiday.
I wish that could be possible, but I don't think so, because the AI is as good as what you put in, and that's the biggest challenge of artificial intelligence in arbitration world or in any judicial process, because what happens is that you put in the facts, you put in the law, and the reasoning would come out. But apart from that, AI can be a great tool which can be used for the speech recognition, for live transcript, for translation, because many a times we have faced this problem about translation and on the live testimony going on. It takes a lot of time. When the witness knows English also, they plead ignorance, and they get more time to think whereby the translator is translating it. So those are the challenges we have always faced. But the biggest challenge which we face and the downside is the availability of the technology across the users of the arbitration world, because we have not advanced that much as we should have by now. Although I'm talking specifically about Indian, this thing, of course, for international arbitration is fine, but for the domestic arbitration, we need the full support of the live transcript, which is online, and also virtual hearings to come into the reality. Data processing and security, again, is a big challenge, because in a physical world, it's very easy to maintain the security, but in the virtual world, it becomes a great challenge. Now, the only problem is with regard to having a protocols, and either we have the now confidentiality under the statute as per 2019 amendments in India. We never had the confidentiality, but we always had the contractual clause of confidentiality to be maintained, and that could be one of the ways to enforce the confidentiality. And we have also challenges, as Sharina was pointing out, is that unless we have the virtual reality or augmented reality where we have the 3D hearing space, which is very expensive, and it's just the question of time that we would have to have that to have the complete transparency and due process in the arbitration, to see as if you are present in the room. You can see all the four sides of the person who is sitting in front of you rather than a 2D image. So that's going to be the future, and if till such time that happens, we may need to deal with multiple cameras, or the confrontation of the documents to the witness also becomes a challenge when you are on a screen. So those are the challenges we always face when we are dealing with the technologies. But if you talk about data privacy, ICC has come up with a guidance note in 2020 with regard to the data privacy, especially with regard to virtual hearing. And also it provides how the documents have to be shared on the platform and how it is to be maintained. Recently, ICA, New York Bar, and CPR Cybersecurity has come up with a protocol for international arbitration. They've come up with a lot of principles for maintaining the standard of cybersecurity and determining the reasonable cybersecurity measures. So those who are interested should definitely look up to that, because there are around 14 principles which are laid down in this protocol, and it's quite handy for anybody who is concerned about cybersecurity for international arbitration.
That's great. Thank you. Chirag, did you have any quick comment on this, or otherwise I can request you to maybe add to your comment on third-party funding when we hear from Gautam. Is that all right with you, Chirag? Thank you. So with that, at the end of the day, as the Americans say, it's show me the money. And that's where the rubber hits the road, and the bankers are firmly in the room with third-party funds, investing in law firms in different parts of the world, and taking a much more proactive role in which disputes get litigated or arbitrated, how and by whom. With this, can Gautam please walk us through what are you seeing with risk mitigation and financial models in disputes that might outlast this?
Sure, thank you, Shreyas. This whole area has been, it's been evolving, as we all know, and a number of the funders are looking to enter new markets. So I'm aware that certainly in the Indian market, they've been very visible for the last 2 or 3 years, speaking at conferences, getting around the circuit, meeting people. And that's to be expected, because, to utilize your comment, that's where a lot of the money could be, so, someone wants to show it to them, right? So in terms of making a return from cases. So, but I think, the immediate temptation is to think that this pandemic situation that we're in is going to lead to a tidal wave of litigation and arbitration. I don't think any of us can make that assumption. It might, there might be something. I remember very well from the global financial crisis, 2008, 2009 onwards, there was a lot of disputes that came out of that. But that was a very different situation, I think, to this. I don't think you can say it's comparable. And funders by themselves are businesses, right? So yes, they want to invest in cases, but they are also very cautious because they want to take on the right sort of cases. So the due diligence involved in cases has always been quite meticulous. I think it's going to be even more meticulous, especially when lots of funders have found themselves embroiled in litigation themselves about their own practices. I mean, I'm sure that we're all aware that some of the well-known funders have been cited in various legal proceedings for their practices and for, fraud on shareholders and that sort of thing. So there's a lot of, backdrop to this, but certainly there is room for third-party funding, as long as it's, of course, the right case. And especially in this era, I think insurers are going to be even more cautious than they were previously. There is, I think, one of the things that's always been talked about is the opportunities in investor-state arbitration as well for third-party funding, not least given the often telephone number-like numbers that are being claimed in damages in these sorts of claims. And, whether that's right or wrong in terms of whether it's appropriate for third-party funders to get involved, that's not for me to say. That's beyond my pay grade. But it's certainly a very topical issue. But ultimately it's about access to justice, right? And as long as it's being utilized properly, there is clearly an opportunity for it. But I would caution against saying that we're about to see a tidal wave of engagement by third-party funders. But it's certainly one way of mitigating risk. I'll hand over to the far more better informed Chirag to follow me.
Chirag, over to you. And please take an extra minute if you'd like on the tech piece.
Yeah, thank you. So I've been interacting with a number of general counsels because as Center for Arbitration and Research, we are conducting a survey how businesses would be dealing with the disputes in a post-COVID scenario. And there's almost a consensus that especially in consumer-based non-essential services sector, that they would not like to go for arbitration or litigation because the businesses have been deeply impacted, especially consumer-focused services. And there's a sense that they would like to focus more on mediation, or they would like to focus more, as Tejas earlier pointed out, Armedab. So businesses really don't want to invest money after so much of an economic downturn. And what would be prudent for every business would depend upon the sector growth, would depend upon the government policies also. And then ultimately, the kind of business and the kind of recovery time they will take in coming back to the normalcy. So I feel that mediation is going to play a great role as a strategy to reduce cost because of economic downturn, and there is more tendency to amicable settlement by other ways, maybe by negotiations or maybe by compromising the disputes. And with regard to the technology part, which I left, Tejas pointed out that yes, technology has given us a lot of scope and it helped us in saving that we are not jobless. But I always feel that technology is a double-edged sword. So yes, it has its advantages, but if it's not properly handled, if the people who are handling it or who are not properly trained in technology, then there can be side effects also. There can be a lot of repercussions on the data privacy and security also. And what is required? There may be thousands of protocols, laws, etc. At the end of the day, what is required is whether the parties, tribunal are taking an informed decision or not about the use of technology or not. How can we empower parties and tribunal to take an informed decision? And I think that's the most critical part, be it dispute resolution, be it virtual hearing, be it virtual practices in the arbitration, or be it case management conferences. The more parties sit together with the tribunal, decide the future course of action, least are the likelihood of the due process concern. They may choose pre-virtual arbitration agreement on the use of technology, or they may do different due diligence exercises. But the end of the day, it should be a conscious decision based on the informed data. Yes, over to you, Shreyas.
Thank you. And now over to the questions sessions. And we've had a robust participation from the audience, and I'm very thankful to them. May I begin perhaps with you, Sharina? There are a couple of themes I want to pull together. One is this view on, is it really just enough of hot air? And can we just only please have documents, only arbitration in all matters? Is that even possible? And also a very important matter, which is close to all our hearts on this panel, is this issue of inclusion and representation of diversity. I know that they're two unconnected topics, but they are terribly important, and I want to make sure that we give some airtime to both.
Shreyas, touching upon the first one, and I see that that's a question from some in the audience. I don't think you can have a documents only arbitration for all arbitrations, but I do think it's such an efficient way forward. I myself have sat as an arbitrator where we had a documents only arbitration, and we rendered the award within 6 months of the arbitration commencing. It was extremely efficient, but again, it wasn't documents heavy. And frankly, there wasn't a need for the tribunal to want to see the witness. It was all pretty clear in the witness evidence. So I don't think you can say one size fits all. I think it just really depends arbitration to arbitration. But I do think, you know, in India, we should be seeing a lot more of these document arbitrations. Turning to your next question, which is about the inclusion and diversity. I think when one talks about diversity in arbitration, there are so many forms of diversity, from issues regarding the appointment of women as arbitral tribunal members or counsel, appointments from different geographies, appointments of different nationalities. And I think it's quite clear from figures that the geographical makeup of arbitral tribunals sadly does not reflect the increasing geographic diversity of parties and international practitioners. So I was actually looking at some statistics the other day because this is a topic that's quite close to my heart. And the ICC 2018 statistics, for example, suggest that although the ICC appointed and confirmed 87 different nationalities, Western European candidates remained the most prominent. The ICC has acknowledged that the figures are unsatisfactory, and they're committed to doubling its efforts towards greater regional diversity. 210 out of 223 appointments in the SEC cases were again from Europe. And whilst the LCIA reported a higher total percentage of female arbitrator appointments, it sadly experienced, and this is very strange, a bigger discrepancy on the origin of those appointments. So it's interesting, 1 in 3 arbitrator appointments by the LCIA in 2017 was a woman, compared to 1 in 6 who were appointed by parties or co-arbitrators. In total, 24% of arbitral appointments were women, which was an increase by 3% by the LCIA. And the LCI has also seen more change in the nationality of arbitrators appointed. And whilst British arbitrators still make up 60 to 65% of those appointed, in recent years there has been a rise in appointments from Western Europe. SIAC as well has similarly seen an increase, with 30% of SIAC arbitrator appointments being women, which is a 7% increase from the previous year. Also interesting to bring in Africa, because a 2018 survey of African practitioners, which was published by SOAS, found that although 82% of participants had undertaken formal training in arbitration, less than 18% of them had actually sat as an arbitrator. So that's quite sad, actually. And so there are a number of pledges and initiatives to do with diversity. The Equal Representation in Arbitration Pledge, which is for the equal representation of women in arbitration, an objective to improve the profile and representation of women in arbitration, to appoint women as arbitrators on an equal opportunity basis. I'm on the steering committee of the pledge. Today, the pledge has 4,197 signatories from around the world. And I actually launched the pledge in India 2 years ago, and it's been quite successful. We've got a great bunch of women, and if there are women out there who are interested in arbitration and would like to join this, please do send me an email. Also, there is the African Promise, which has been modeled on the pledge, which aims to promote diversity and inclusion in international arbitration by improving the representation of African arbitrators. And this promise has 300 signatories as well. So there's quite a lot of pledges going on in the arbitration community, and I think it's bearing some fruit. But it's not really the institutions It's looking at the arbitrators and the parties for considering this inclusion.
No, thank you for that very comprehensive overview. Gautam, can I turn to you on another trend that is here to stay, which is impacting behavior? We did touch on it briefly, but with the passing of the Singapore Convention on mediation, do we really see a far more integrated approach to problem solving rather than dispute resolution by A or B process? Also, we heard about construction disputes. Could you also maybe touch upon dispute boards and the other forms of dispute resolution that parties would look to?
Yeah, of course, Shreyas, thank you. I think, the Singapore Convention was an interesting instrument, although it's not as widely, signed up to as perhaps the perception might be. And anyway, as we all know, so, tongue in cheek, things that are often tagged with Singapore have efficiency and will work as sort of substrata to them. No, but I think all joking aside, mediation is a critical concept here. Shreyas mentioned, Tejas mentioned at the very beginning about sort of this whole concept of mediation, med-arb and everything else. And it's a very important concept, but because it can be very efficient. Shrina mentioned also one of her GC clients had mentioned a propensity to consider mediation more, but we have to step back here. People have to understand what mediation actually is. You, Shreyas, you sit as a mediator. We all here have a lot of experience of acting as counsel in mediations, burning the midnight oil often, and eventually signing something at 3, 4 in the morning, which is great, right? But what is the common factor here? The common factor here is the skills set of the mediator. There are some very good mediators that I've come across, and some frankly poor ones who are not very good at all. And the skill set is important here. So we don't have enough really good mediators. See, when you talk about arbitrators, there's a huge body of arbitrators out there. Yes, it should be more diverse, absolutely. And like Shrina, I'm very passionate about that. It has to be a lot more diverse in all respects. But mediators, frankly, there needs to be more of them. If you think about mediation in the UK and in the US and Singapore, it's very well developed. It's very well developed. But in other countries, it's not so well developed. So in India, I know there is an increasing trend for knowledge, training, and awareness. But how many people truly can you say are accomplished and experienced mediators in India? You can't really say that. With all respect, you can't say that. Now, part of that hopefully will come, but it's also generational. We have to get over judgeitis, as I call it. There's been a huge sort of an over-deference to former judges. And I think there's a huge room for seasoned and experienced practitioners, India-based, like yourself, Tejas, academics like Chirag, to all have a role in this, quite frankly, because that's important. So you expand the pool base, but also importantly, you raise awareness of what mediation is. Like Shrina, a number of my clients don't actually understand what mediation actually entails and what the process is. They think, oh, it'll be really good because in one day we'll resolve this dispute. Now, yes, most cases do settle as a consequence of mediation, but you have to get there by a process. There has to be a mindset shift. Not so much we're going to be adversarial, we're going to fight every single point. Mediation is about compromise. So I think that's important. And just very briefly, Shreyas, you mentioned about alternative resolution in other fora. Yeah, I think disputes boards in construction, expert determinations, all of these things all have their place. And increasingly will become, I think, more remote anyway, because of the consequences of COVID. So I think everything has its place, but mediation is the big weapon out there, I think.
No, thank you for that. And I just one small interjection. There are many eminent mediators of Indian origin. They're just not as well known. And so I would love to have a separate call with you and share some of those names. There are many there. And so, and to even the listeners, there is an underutilized pool of mediation capability that we should all, I think, tap into. Tejas, there are a lot of questions out there on enforceability of award and any tips that you might have. Also, there have been the issues of enforceability of a few emergency awards. And this is really, again, a cusp of the interaction of courts and tribunals. Could you kindly reflect on this? And also, there are a couple of questions that we've seen on video conferencing. How practical or not is it? So again, two different themes, but both would be kindly addressed by you, Tejas.
Sure. So as far as the emergency award is concerned, there is a specific question about a recent case of Delhi High Court, where it so happened is that the party exercised the right to go to emergency arbitration first in Japan, and then came to Delhi High Court as if it's filing an appeal against the emergency arbitrator's award, where the emergency arbitrator did not grant relief. And Delhi High Court said that looking at the nature of the petition, which is filed under Section 9 for interim relief, it is not a kind of an enforcement of an emergency award, or it is not a challenge of an emergency award, where the parties had a seat outside India. The Japan rules were applicable, institutional rules were applicable. So that doesn't mean that the Indian courts are not recognizing the emergency award. If there are emergency awards, the courts are recognizing and granting the relief in the same terms as the emergency award. But if the parties have chosen emergency arbitration and gone and been unsuccessful, then you can't have the second bite at the cherry, and you can't have that second chance under Section 9. So that's the limited aspect of that. But my view is that emergency arbitration, although it should have been now part of the Indian Act, but we do recognize that under Section 9 nonetheless. As far as the challenges which we face through video conferencing, yes, we have to talk about virtual reality and augmented reality to come over the challenges which we face for at least cross-examining a witness, because I saw some questions they're saying, how do we stop somebody briefing on phone or on this thing? So the how we are doing is that at least one of the members are present along with the witness, who can see what is happening, or at least you have a few cameras which can also be visible that witness is not looking at something while answering questions, or there is nobody else present in the room. That is something we can help. Purposeful switching off of the video or audio while the system is on can also be there with a backup plan, or pausing the hearing for some time. Those are the practical challenges we always face. But in any hearing that can be there. So we have to come over it by ensuring that the technology is there, or at least a backup is there to ensure that those tactics are not followed in arbitration.
Thank you very much. And coming to the end of this great webinar, Chirag, can I ask you to speak on two topics? There are many students listening in, and many of them are very anxious and worried. Do they have a future at all? And what are universities doing to slightly change the way they teach? And more fundamentally, there's a question out there to say, who can be an arbitrator? I wish clients will ask this question more often, rather than simply say A or B, judge or lawyer. So can you please take those two on? And with that, you will have the last word, Chirag, unless there's a compelling comment from any of the other panelists. Chirag, over to you. Unmute, please.
Thank you for reminding me again. Thank you, Shreyas, for asking that question. In fact, as I am talking to my first batch of students, our first batch of students from our university have passed out this year, and many of them are interested in commercial arbitration, investment arbitration. And there's a lot of anxiety in the students that how they can, pursue the career in arbitration, especially they said we want to pursue the career in arbitration, how we can be so specifically, despite having so many job crunches, we all understand economic. So there are real concerns amongst the students, but I think that will only be resolved by the time, and all of you are from law firms, can better help them in that way. Who can be arbitrator? So to my understanding, generally people ask me, what is arbitration? I describe it in a very normal say. I say arbitration is nothing but litigation, but you choose to get your own judge, whom we refer as an arbitrator. You choose to have your own place, which we refer as venue or seat, depending upon the legal terminology, and you yourself pay to that judge. And you decide what law will apply to you. So in that sense, arbitration is not a rocket science. And if anybody want to have X person as an arbitrator or Y person as an arbitrator, there's a complete freedom, unless we get into the regime of 2019 Amendment Act, where we'll have Arbitration Council of India and there are minimum qualification. But as far as present regime is concerned, I don't see any condition which will stop any person to become an arbitrator, unless the parties have a different viewpoint. So anybody can be an arbitrator, and in fact, we have developed a system at our university where various disciplinary issues amongst the students are decided by the student arbitrator or student mediator. And so in order to inculcate that culture, because the major problem, see, in almost all the trainings which we give on mediation and arbitration, our major focus is you can be an arbitrator. Even all the retired High Court, Supreme Court judges are arbitrator. But what you need to do, you need to come out of your adversarial mindset. So we constantly emphasize that a person during the 5-year law training does not get that adversarial mindset, so that he has to always contest and argue and oppose everything, whatever comes. So can you develop that mindset where you tend to resolve the disputes? And if you have that mindset to resolve the disputes, if you have that mindset to be fair, impartial, then I think it's very, very, a good option for people to become an arbitrator or a mediator. So important thing is to get out of that mindset. Yeah. Thank you.
Thank you. I remember a lighter moment when the debate, Parliament was debating this bill, and Tejas, you might remember the WhatsApp forward we all got, when one of the members in Parliament said, hey, you know what, politicians can be arbitrators too. And he pointed out to learned members of the opposition. So sometimes in our meaning to be inclusive and everything else, we have to be careful for what we wish for. And with that, I really thank the organizers. They did ask me to say there is somebody with a hand that is raised. So if there's a burning one question, I was asked to leave room for that. And if not, it only leaves for me to, I take that as a no. So it only leaves for me to thank profusely the eminent panelists. Thank you, Sharina. Thank you, Gautam. Thank you, Tejas. Thank you very much, Chirag. And stay well and stay safe. Thank you.
Thank you, Shreya.
Thank you.
Thank you.
Thank you. Bye-bye, everyone.
Bye.